Force majeure clauses are often misunderstood in Australian contract law because many people assume an unexpected event automatically excuses them from performing a contract. In reality, force majeure only applies if the contract itself creates that right, and whether you can rely on it depends almost entirely on the wording of the clause. A force majeure clause is a contractual mechanism that may suspend, delay, or excuse a party's obligations when extraordinary events outside their reasonable control prevent contractual performance. Common law examples include natural disasters, pandemics, government restrictions, war, industrial action, or major supply chain disruptions. However, there is no universal definition of force majeure in Australian law. Each clause is interpreted according to its own wording, meaning two contracts dealing with the same event may produce completely different legal outcomes. One of the biggest mistakes businesses make in assuming that increased costs or commercial hardships are enough to trigger force majeure clauses. In most cases, they're not. A contract becomes less profitable or more difficult to perform will rarely excuse performance unless the clause specifically allocates that risk. Similarly, parties often overlook important procedural requirements, such as giving written notice within the specific time frame, taking reasonable steps to minimize the impact of the event, and providing evidence that the force majeure event genuinely prevented performance rather than simply making it more inconvenient. Failing to comply with these requirements can prevent a party from relying on the clause altogether. If the contract does not contain a force majeure clause, parties may instead need to rely on the common law doctrine of frustration. However, frustration is a much narrower legal principle and applies only where an unforeseen event fundamentally changes the nature of the contractual obligations so that performance becomes radically different from what the parties originally agreed. Courts set a high threshold, and increased expense, delay, or commercial inconvenience alone will usually be insufficient. Because force majeure disputes are heavily dependent on contractual wording, businesses should never assume they are automatically entitled to suspend or terminate a contract following an unexpected event. Reviewing the precise terms of the agreement, understanding the notice and mitigation obligations, and assessing whether the event genuinely falls within the clause are critical steps before taking any action. Getting that assessment wrong can expose the business to breach of contract claims, damages, and significant commercial losses, even where the disruption itself was entirely outside its control. Contact us today for a free 30-minute consultation with one of our experienced team of commercial litigation professionals and let us help you protect your rights.